Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
We will bring the jury.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Oh, for crumb's sake. I didn't ask you to interrupt me.
Is that correct?
Dati mihi Anglican, please.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Podcast Thursday to you. It is great to be here. Good morning. Everyone come on in, take your seats. Welcome especially to Shmoopy. Shmoopy first in chat again today. This is a repeat offense for you. So you know the punishment. We're going to send it to you to internet ownership. Everything IP related worldwide is now your responsibility for the day. You'll do great. You have to do great. We're all depending on you. Is it Thursday already? Is it MJ? Yes, it's already Thursday. My question is it morning already? Wow, it's early. Watched someone taking a hammer to a taillight last night on video. You found the Canton tapes, Teresa? You found the Canton police tapes? Oh, they're looking for those. Let's see. Good morning. Nurse for God says, can you add me to the birthday list, please? Can we add Nurse for God to the birthday list? That would be fantastic. Good morning. Before we do the birthday songs, well, we're adding Nurse for God. Let me just say.
Happy birthday. You look good.
Josh, it's early. Try being up at 4 a.m. dealing with the cops. Well, the cops were dealing with your problem, if I say so myself. I happen to know a little bit about it. But they were the cops were the good guys, and you called them to help you. It was dealing with the problem. Anyway, I'll let you discuss that if you want to. Yesterday after work, since we got done a little bit early yesterday, with this court ending at 4 o'clock in the afternoon, I ran down to the city offices, and I said, hey, look, I watched, was it Monday night or Tuesday night? I can't remember. Tuesday night, I think it was. I watched your little town hall meeting, right? That you filmed in portrait mode on your phone from the audience. And you can, like, if you squint really, really hard, you can see where the council members and the mayor way back. It was terrible with no microphone. And all we heard the whole time was the guy who was sitting right next to us going, the whole time. Just him coughing nonstop. And 7,800 people also watched that. And everyone's like, can somebody please fix the audio? I'm like, look, okay, now I feel bad because it's my town, right? And everybody out there is sort of dependent on me. You can maybe fit, I don't know, 150 people in that room if on a good day, right? If they're all friends and you want to sit next to each other. So I pop down there and I say, hey, I need to talk to you about maybe running your live stream for you. And they're like, how much will this cost? That's their first question. They don't say, what's your name? Who do you want to talk to? No, how much will this cost? I said, look, nothing. I'm just doing this out of the goodness of my heart because you need it, and my fellow townspeople depend on this. And so they send out the town clerk to talk to me. And I said, look, I'm just a YouTuber, but I've got all the gear. Okay, I have everything. If they sell it, I have it. Okay, I can probably help you. Let me run your live stream for you. And I said, and is it okay if I just take a peek up there and just see what we're playing with? Because I've never been to one of these meetings in person. I've always watched, clips online. And I run up there, and this is like a courthouse that was built, I don't know, maybe in the 60s. And it is an old setup. Every single one of the mics for the 8 council members are condenser mics, which means that if a pin drops on the other side of the room, you'll hear it. Okay? They're super, super sensitive. You don't have. This is a dynamic mic. It has a sweet spot that's like, let me show you. Test. See, right here. I've almost got to eat the mic for it to work. That's just how this is designed. That's where it sounds the best. Theirs, you can be like 6 feet away and it still sounds like this. And you hear all the every mouth noise, everything. It's terrible. And so we're going to sing in just a minute. I promise we won't skip the birthdays. Can somebody do the address in chat for the P.O. box? That'd be awesome. So I go and check this out, and they're like, I say, so you run this sound system, and then I'll say this, and they're like, well, how will people be able to hear in the room? I'm like, well, you'll keep your sound system on. And they're like, we can't do that. I'm like, why? They say, because it makes so much noise. They have got the gain cranked all the way up so that people can hear better. It is just nonstop feedback, nonstop, just like you turn it on, it's just like squealing. Like, see, you can't do anything. It just makes so much noise. You turn it on, and I'm like, oh my goodness. So I go through and I photograph all their little components that they've got, and it's like duct taped together and wired under the desk, and people kick it nonstop. Half the cables are broken. And I was like, okay, maybe I bit off more than I can chew here. I'm thinking it over, because I can run my live stream so that everyone can hear on the live stream, but I'm not the guy who's like, and I'll make sure everyone can hear. No, I only worry about the people online. That's it. I'm not going to feed my output back into the sound system, because then it messes up my output. Anyway, that's where I'm at. That's where I'm at yesterday. So, I might go back and just tweak their settings just so that their sound system works, and tell people, look, if you can't hear, you need to buy new hearing aids, not necessarily crank the volume on the master control. That's what it is. All right. Do we have any birthdays today? Well, we think this over. I know we have at least one. Nurse for God is out there waiting to be sung to, and you will. At least you tried. I think I'm going to do it. I'm like, look, I'll just, maybe a 2-camera system, pan, tilt, zoom in the back so I can zoom in on whoever's talking, and then, I don't know what I just did. Oh, hit a button that didn't matter, but now I'm back. Why is it buffering? Why is what buffering? Who's buffering? So Josh, you've missed Nurse for God on here. We need to add Nurse for God. It's all right. We're going to add Nurse for God on this list. I will copy and paste it. Oh, hang on. It's a golden birthday as well. We've got a couple. Okay, so I have to take these, copy, paste. We've got Nurse for God's tomorrow. Oh, okay. So you followed the instructions, and I did not. We've got Grayson. I'm going to grab Grayson, who's a golden birthday today, 13 on the 13th. Copy, paste. I hear "We Are A1" in my studio. Hey, bud. How you doing? Oh, thank you. More waters. Awesome. I'll need these this afternoon. Thank you. Waters from the delivery boy. All right. Nurse for God is tomorrow. All right. Josh, you got it for me. I was about ready to paste. And hit enter. There we go. All right. Here's who we're singing to. We're singing to Christy Robinson, Grayson, and Lee McIntosh. So when I say we, that means all of us. That's not just me. So everyone, if you would stand up where you are, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with the neighbors, warm up with me if you will. La 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 la. There we go. It's really just sort of tuning us to the same key. All right, we're going to sing happy birthday to these wonderful folks. Happy birthday to you. Happy birthday to you. Happy birthday, Christy Robinson, Grayson, and Lee McIntosh. Happy birthday to you. Alexis, didn't you ask for my address? And I said, can one of the mods put it in chat? All right, what's your question? I'll answer it right now. In the middle of the birthday song, Alexis, do you just need my address? To everyone who's celebrating their birthday today, happy birthday. I realize there are a million special days, but today is your special day. I guess among a million, yours would come up quite often if you did the math. Like at least 1 out of 400. We're probably less than that. There's the address right there, Alexis. It's your special day. And I realize there are a million places you can be, a million people you can celebrate it with, but you chose to be here with us. The privilege, the pleasure, the honor is all ours. Do I like hot sauce? Yes, I do. I do like hot sauce. Help yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's. There was another one. Andy's Grill, Bob Evans, and Tammy Dunlop's house. I missed one in there. Tammy's are the best. Do you like hot sauce? Yes, I do. Here's a little mule sauce. I happened to buy 8 bottles of this because I had a credit with the store. Oh no. Let's see. Buffer. Buffer. Ryan has a birthday too. Okay. That means we have to do on the last verse, which is, I think, the drum solo. Here we go. We'll sing to Ryan as well. Here we go. Happy birthday to you. Get your drumsticks ready. Happy birthday to you. Happy birthday, dear Ryan. Happy birthday to you. Yeah, I barely hit that one. It was low. It's low in the morning. Ryan, happy birthday as well. Have yourself a wonderful, wonderful birthday. Thank you very much. We are going to go to a couple things. First of all, we're going back to New Hampshire, but they don't start. I don't know why, but New Hampshire works half days every day. I wish I didn't know that was an option. Honestly, when I started doing this, I didn't know half days were an option. I figured that 8 hours a day is what you work, and so that's what we typically do. Not in New Hampshire. Half days is what they do. So. We don't start there till, I don't know, 10-ish, and then we're done by 4 because that's how they roll. Will the mini RAs sing for us to you on your birthday? I don't know. Maybe if I twist their arm, they'd have to say that there's. They'd be like, "What's in it for us? If we sing, what do we get?" That's what they'd say. I'll let them have the Legos. How about that? Alexa says I have some small something from a company in Maine for you. That sounds awesome. Companies in Maine are just cool. Maine makes some cool stuff. You can get everything from syrup, like pure maple syrup up there. That's pretty good. Lobster. Tried that now. Might have to try it again when it's a little bigger. But anyway. I'm sure they're working, just not in court. Right. Yeah, Ohio Mama. I saw the wink there. They're working. They're working. Remember all the days and nights for Cavalcante? Oh my goodness, that was brutal. It was brutal. All right. Before lobster trauma, I have lobster PTSD. What is that? What flavor is it? I'm not sure what I'm holding right here. Where did it come from?
A Pepsi stick.
A what?
I got a Pepsi stick and I put it in.
Oh, it's a Pepsi stick? I'm not sure if that's meant for drinking. Is it? What is it?
It tastes like water and Sprite.
It tastes like water and Sprite? Weird. It's horrible. Okay. It looked like something I found on the side of the road once on a cleanup. It didn't look good. It didn't look good. All right. So we have court to start. Before we go to New Hampshire, we're going to jump right now to the jury instructions that are happening right now in the case, the 2-for-1 case. We might actually have a verdict before New Hampshire gets their act together. Excuse me, before New Hampshire begins their case this afternoon. So let's listen in right here and see if we can. Let me get them pulled up on screen as well. They're on 2 in 3.
The law as it is given to you.
There we go.
You are not permitted to change the law, nor to apply your own conception of what you think the law should be.
No juror nullification allowed.
A criminal case begins with the filing of an indictment. The indictment informs the defendant he has been charged with offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. For each offense charged in the indictment, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of that offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If, after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt, and you must find the defendant guilty of that charge. If you are not firmly convinced of the truth of that charge, you must find the defendant not guilty of that charge. O'Shea Jordan has chosen to represent himself. He has a constitutional right to counsel. He also has a constitutional right to represent himself. The fact that he has chosen to represent himself should not influence you in any way. The court has assigned attorney Allison Hibbard to assist defendant O'Shea Jordan upon request. Evidence is all the testimony received from the witnesses, the exhibits admitted during trial, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. If you awake in the morning and you see the ground is covered with snow, that is circumstantial evidence that it snowed earlier. If you see human footprints in the sand, that is circumstantial evidence that someone had walked there.
Or that you're on the beach.
To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight and probative value. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Some exhibits may appear to have been deleted, redacted, or omitted. There is nothing improper in any deletions, redactions, or omitted material, and no one has tampered improperly with such evidence without the knowledge of the state, the defense, and the court. In fact, such deletions, redactions, or omissions have been done at the request and agreement of both parties. Any material that has been deleted, redacted, or omitted is irrelevant to your determination on the issues in this case. You are to infer nothing by what you think may be deleted, redacted, or omitted. Do not conjecture or speculate on what was not presented to you in the exhibits.
The reboot's all I can
You
offer.
are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may use the tests of truthfulness which you use in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the accuracy of the witness's memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. By using these tests, you may assign to each witness's testimony such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that he did not testify must not be considered for any purpose. Police officers have testified in this case. You are not to give any greater or lesser weight to their testimony based solely on the fact that they are police officers. In count one, the defendant is charged with having a weapon under disability. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June, 2024, in Lake County, Ohio, the defendant knowingly had a firearm, and the defendant had been previously convicted of felonious assault in the Lake County Court of Common Pleas, case number 08CR000271, dated December 23, 2008.
It was a ghost gun.
A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. Had means possessed. A person has possession when he knows that the object on or about his person or property, or places it where it is accessible to his use or direction, and he has the ability to direct or control its use. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable but that can readily be rendered operable. When determining whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, the trier of fact must rely upon circumstantial evidence, including but not limited to the representations and actions of the individual exercising control over the firearm. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon, or possessed, carried, or used as a weapon. Evidence was received that the defendant was previously convicted of felonious assault. That evidence was received because of a prior conviction is an element of the offense charged. It was not received, and you may not consider it to prove the character of the defendant in order to show that he acted in conformity with that character. If your verdict is guilty on having a weapon under disability, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio. You will sign a verdict finding that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture if you unanimously find by clear and convincing evidence that the property was 1, contraband involved in the offense of having weapon under disability, or 2, an instrumentality that was used or intended to be used in the commission or facilitation of the offense of having a weapon under disability.
The jury gets to choose if he gets his stuff back.
Intended use was sufficient to warrant or justify the forfeiture of that property. If your verdict is not guilty on having a weapon under disability, you will not decide the additional issue about the forfeiture of the pipe, cocaine, firearm, magazine, ammunition, and marijuana. Clear and convincing evidence is evidence that produces in your mind a firm belief or conviction about the issue in question. It must be more than evidence that simply outweighs or overbalances the evidence opposed to it. Contraband means any property that is illegal for a person to acquire or possess under a statute, ordinance, or rule, or that a trier of fact lawfully determines to be illegal to possess by reason of the person's involvement in an offense. Instrumentality means property otherwise lawful to possess that is used or is intended to be used in an offense. An instrumentality may include, but is not limited to, a firearm, a mobile instrumentality, a computer network, a computer system, computer software, a telecommunications device, money, and any other means of exchange. In deciding whether an instrumentality was used or intended to be used in the commission or facilitation of the offense of having weapon under disability in a manner sufficient to justify its forfeiture, you must consider any of the following factors that you decide are relevant. A, whether the offense of having a weapon under disability could not have been committed but for the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the offense of having a weapon under disability. And C, the extent to which the instrumentality furthered the commission of the offense of having a weapon under disability. In count 2, the defendant is charged with having a weapon under disability. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June, 2024, and in Lake County, Ohio, the defendant knowingly had a firearm, and the defendant had been previously convicted of possession of cocaine in the Lake County Court of Common Pleas, case number 08-CR000271, dated December 23, 2008. Knowingly, had, possession, firearm, and deadly weapon have the same definitions as in count 1 above. Okay. Evidence was received that the defendant was previously convicted of possession of cocaine. That evidence was received because a prior conviction is an element of the offense charged. It was not received, and you may not consider it to prove the character of the defendant in order to show that he acted in conformity with that character. If your verdict is guilty on having a weapon under disability, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio. You will sign a verdict form, a verdict finding that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture if you unanimously find by clear and convincing evidence that the property was 1, contraband involved in the offense of having a weapon under disability, or 2, an instrumentality that was used or intended to be used in the commission or facilitation of the offense of having a weapon under disability, and the use or intended use was sufficient to warrant or justify the forfeiture of that property. If your verdict is not guilty on having a weapon under disability, you will not decide this issue about the forfeiture of the pipe, cocaine, firearm, magazine, ammunition, and marijuana. Clear and convincing evidence, contraband, and instrumentality have the same definitions as in count 1. In deciding whether an instrumentality was used or intended to be used in the commission of or facilitation of the offense of having a weapon under disability, in a manner sufficient to justify its forfeiture, you must consider any of the following factors you decide are relevant. Whether the offense of having a weapon under disability could not have been committed but for the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the offense of having a weapon under disability. And C, the extent to which the instrumentality furthered the commission of the offense of having a weapon under disability. In count 3, the defendant is charged with possession of cocaine. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June, 2024, and in Lake County, Ohio, the defendant knowingly obtained, used, or possessed cocaine, or a compound, mixture, preparation, or substance containing cocaine, a Schedule II controlled substance. Knowingly has the same meaning as in count 1. Possess or possession of drugs means having control over such a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. Ownership is not necessary. A person may possess or control property belonging to another. Possession of drugs can either be actual or constructive. Actual possession exists when the circumstances indicate that a person had cocaine or a compound, mixture, preparation, or substance containing cocaine within his immediate physical control. Constructive possession exists when a person was aware of the presence of cocaine and was able to exercise dominion and control over that cocaine, even though that cocaine may not have been within his immediate physical control. Both dominion and control, and whether a person was aware of cocaine, may be established through circumstantial evidence. Thus, the state may establish constructive possession by circumstantial evidence alone. If your verdict is guilty on possession of cocaine, you will also decide another issue. The state of Ohio claims that any right, title, or interest of the defendant in the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio. You will sign a verdict finding that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture if you unanimously find by clear and convincing evidence that the property was 1, contraband involved in the offense of possession of cocaine, or 2, an instrumentality that was used or intended to be used in the commission of or facilitation of the offense of possession of cocaine, and the use or intended use was sufficient to warrant or justify the forfeiture of that property. If your verdict is not guilty on possession of cocaine, you will not decide this additional issue about forfeiture of the pipe, cocaine, firearm, magazine, ammunition, and marijuana. Clear and convincing evidence, contraband, and instrumentality have the same definitions as in count 1. In deciding whether an instrumentality was used or intended to be used in the commission of an offense or facilitation of the offense of possession of cocaine in a manner sufficient to justify its forfeiture, you must consider any of the following factors you decide are relevant. A, whether the offense of possession of cocaine could not have been committed but for the presence of the instrumentality. B, whether the defendant's primary purpose in using the instrumentality was to commit the offense of possession of cocaine. And C, the extent to which the instrumentality furthered the commission of the offense of possession of cocaine.
Okay, now you got like 800
Count
people
4, the
here.
defendant is charged with soliciting. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June, 2024, and in Lake County, Ohio, the defendant knowingly solicited another to engage in sexual activity for hire in exchange for the person receiving anything of value from the defendant. Knowingly has the same meaning as in count 1.
But it was just
Solicited
companionship.
means to seek, to ask, to influence, to invite, to tempt, to lead on, or to bring pressure to bear. Sexual activity means sexual conduct or sexual contact, or both. Sexual conduct means vaginal intercourse between a male and female, anal intercourse, fellatio, and cunnilingus between persons regardless of sex, and without privilege to do so, the insertion, however slight, of any part of the body or instrument, apparatus, or other object into the vaginal or anal opening of another. Penetration, however slight, is sufficient to complete vaginal or anal intercourse. Sexual contact means any touching of an erogenous zone of another, including without limitation the thigh, genitals, buttock, pubic region, or if the person is a female, a breast, for the purpose of sexually arousing or gratifying either person. Sexual activity for hire means an implicit or explicit agreement to provide sexual activity in exchange for anything of value paid to the person engaging in such sexual activity, to any person trafficking that person, or to any person associated with either such person. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings.
Thanks, Judge.
If you find that the state failed to prove beyond a reasonable doubt any of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings.
Master Ayden, thanks for the gift
The
of
charges
membership.
set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged.
I'm trying not to
It is alleged
imagine
that
the
offenses
judge
took
reading that
place
instruction
on
in an
June 20,
ASMR voice.
2024. It is not necessary that the state prove that an offense was committed on the exact date as charged in the indictment. It is sufficient to prove that the offenses took place on a date reasonably near the date claimed. You will have with you in the jury room the following verdict forms, one for each count. Each states, "We, the jury, being duly impaneled and sworn, find the defendant," and then there is a blank you will fill in either guilty or not guilty according to your findings. There is a place for 12 signatures. Your verdict must be unanimous, and all of you must sign the verdict form in ink on the line next to your juror number. Counsel will now present their closing arguments. The state will go first, followed by the defense, and then the state will have the last opportunity to address you since they have the burden of proof.
Okay, as they get ready to do this, let me just say, I've been ordering crime scene evidence from Amazon today. Well, copies of crime scene evidence. Is this a normal thing to do? It'll be here by Friday. Let me get to zoom in on that PowerPoint.
Ladies and gentlemen of the jury, thank you for your time and attention to listening to the presentation of the testimony over the past couple of days. In this case, you heard about a lot of testimony that you probably didn't expect to hear.
Yep.
You heard testimony about a gun, about drugs, sex, and prostitution. In my opening statement, I told you that this was a chaotic scene. There was screaming, there was a physical altercation that led to the arrest of all three individuals: the defendant, Destiny Thomas, and Kashonda Lewis Ganell. I asked you in opening to look past all the chaos and focus on what the elements are and what the defendant is charged with. We heard from several officers who responded that night on June 20th. Officer Brown was the first responding officer and his backup officer, Officer Lampola. We also heard from Lieutenant Crowley. We then heard a lot of testimony about the process that the Detective Bureau did at the defendant's apartment that night when executing the search warrant, where they found a firearm, ammunition, cocaine, the pipe, and marijuana. We then heard testimony from several people from the Lake County Crime Lab. They testified about their process of receiving the evidence, the process that all the evidence was tested, and what their results were. And you also heard from Destiny Thomas and Kashonda. They were very candid, blunt, frank. Now, you don't have to agree or like or approve of the behavior that they engaged in that night. Their lifestyle and their choices may not be something that is approved by society that people like. but it's the fact of what happened here. And they were presented to you because the state doesn't hide from the truth. They came in here, in Destiny by Video, and they told you what they saw, what they heard, what they observed, and how they felt. They told you what the agreement was that night, why they were going to the defendant's apartment, and what happened inside that bedroom. The defendant is charged with 4 counts. He's charged with having weapons under disability, he's charged with possession of cocaine, and he's charged with soliciting. For all of the counts, these 3 things apply: that it occurred in Lake County, Ohio on June 20th, 2024, and that it involved the defendant, Mr. O'Shea Jordan. Now, count 1, having weapons while under disability. Knowingly had a firearm and has a prior conviction for felonious assault. We know he had a firearm because both Destiny and Kashonda testified about that. There was a firearm located in State's Exhibit 11, and you heard testimony from Jordan at the crime lab. And you heard testimony from Lieutenant Burgett that he had a prior conviction for felonious assault. Now, the element of knowledge is defined in the jury instruction in count 1, and it applies throughout all of the counts. A person is aware that their conduct will probably bring a certain result. We know that the defendant was aware of it because it was in his hand, and his DNA was on it.
Greeners, here's your link.
All of the same evidence for count 1 applies to count 2. The only difference in count 2 is the possession of cocaine charge, as opposed to a felonious assault conviction. Now, you received that testimony like the judge just instructed, because it's an element of the offense. It is not important, and there was no testimony about any of the details of those prior convictions, because that is not what's at issue here. What you are to consider is just solely the fact that he has those prior convictions, and that's it. The defendant's DNA was on the firearm and magazine, and the DNA analysts testified about what that result was, and that it was a very strong association.
They ordered a knife sheath.
We brought in people
from
the maintenance department at Parkway Apartments and the leasing manager. That was the defendant's apartment. There were no other people that lived there. There were no other beds in the apartment. The defendant's belongings were in there. He knew he had that gun, and 2 witnesses saw him waving that gun around. He did not point it at anyone. He did not threaten anyone. But he pulled it out, and he made sure that both of them knew it was there. As I said, count 2 is the exact same evidence as in count 1. Knowingly had a firearm. The difference is the prior conviction is for possession of cocaine. All of the same evidence. You saw pictures of the apartment that the maintenance personnel took when the defendant left his apartment. You saw the picture of his air mattress on the ground. And over top of that air mattress was a metal bed frame. It was referred to as a headboard, a shelf. And you also saw pictures, and we put the map up of the layout of the apartment, of what that apartment looked like, where everything occurred, where people were standing approximately, and where the evidence was found in the defendant's bedroom. Count 3 is possession of cocaine. Knowingly obtain, possess, or use cocaine, a Schedule II controlled substance. We heard testimony from the detective bureaus that they found a pipe in the defendant's bedroom, and they found loose rocks, the white substance. Both of those contained cocaine. The pipe contained residue, and the other loose cocaine was 0.11 grams. You heard testimony about the testing process at the Lake County Crime Lab to look at those pieces of evidence and come to their conclusion. And Destiny and Kashonda both saw the defendant use the cocaine by inserting the pipe into his mouth Kashonda said it happened a few times, and blowing the smoke out. You also heard testimony about the defendant's DNA being on the pipe. 30 septillion times more likely if the mixture on the pipe is the defendant and an unknown person than two unknown people. Makes sense that his DNA would be on the pipe. The crime lab testified that they swabbed both ends of it. And Destiny and Kashonda saw him use it and insert it into his mouth. Kashonda also testified that there was cocaine, or she referred to it as crack, all over the room, on his shelf, on his pillow, on his kneecap, and it was found in his bedroom that night. Soliciting, count 4. Knowingly solicit another to engage in sexual activity for hire and to receive a value or benefit from the defendant. There was testimony about how Destiny and Kashonda advertised themselves. They posted on websites or applications saying that they were in the area, a way to contact them, and that's exactly what the defendant did. There was testimony that there was a phone call, there was a discussion that they were going to come to the apartment and meet with the defendant. They both testified it was 2 girls for 1 price. And this is the testimony that I was talking about earlier in my opening. You don't have to agree or approve of it. In fact, Kashonda even said in her testimony, it was bad enough we were selling our bodies. But that's what happened here. And the state presented it to you because it's part of this case and we don't hide from the truth. There was testimony about what these escort websites entail, and both of them testified that their intention going there was to have sex with the defendant.
Might hear some words here.
There was also a lot of testimony about what they were going to receive. In today's day and age, there was no cash exchanged. It was all sent by the application called Cash App. Send money from one phone to another. They both testified they got paid. They split the money. And Kashonda stated that Destiny performed oral sex on the defendant.
There are the words.
There's a lot of background noise and chaos in this case. And I urge you to reread the jury instructions and focus on the elements that the state has to prove. This case is not about the chaos or yelling. It's not about Kashonda's charges. It's not about Destiny's charges and whether or not they quote unquote robbed or stole from the defendant. This is not about any prior legal proceedings prior to trial. This is not about the validity of a search warrant at the defendant's apartment or the validity of a search warrant to obtain his cheek swab. This is not about how long to the exact minute that people were on scene or who drove who back to the police department. Those are not elements that the state has to prove. This is not about stealing from the defendant. You're not here to determine any charges for Kashonda or Destiny. This is the state of Ohio versus O'Shea Jordan. He's not charged with theft. He's not charged with holding anyone against her will. There's testimony that Kashonda needed her phone. Yes, she couldn't get out because the door was rigged. It was difficult to open, but she was not leaving without her phone that night. I urge you and submit to you that the state has proved its case beyond a reasonable doubt as to every element as charged. And what he's charged with is count 1, having weapons under disability, knowingly have a firearm, and has a prior conviction for felonious assault. Count 2, the same evidence, having weapons under disability. The difference is that prior conviction is for possession of cocaine. Count 3 is possession of cocaine.
Those two should combine.
And that's based on the pipe and the loose cocaine that was collected in his apartment. And count 4, soliciting. Knowingly solicit another to engage in sexual activity for hire and for them to receive a value or benefit from the defendant. Now I put a star here and the words forfeiture specification. Means that if you find the state has proved its case as to the counts that contain a forfeiture specification, that the defendant forfeits his right, title, or any interest in that property that was collected. Look at the evidence that we have here. Re-listen to the 911 calls of Kashonda and Destiny screaming, calling for the police to come that night on June 20th. Look at the firearm, look at the cocaine, look at the pipe. Look at the pictures that we submitted to you and compare them to what the testimony was of the Detective Bureau that night in finding that. And remember, this was the defendant's apartment. There was no other person that was living there with him.
They're sending the
Kashonda
cocaine
and
back to the
Destiny
jury
did not
room?
see anyone else that night. They locked the door with the defendant after they accompanied him upstairs to get a pair of shorts. There was a different type of lock on the door that was not typical of other units in that building. And they used the key several hours later, that same day, about 9:45 a.m., to go into his unit and find these items. And they were exactly how Kashonda and Destiny described them. The state has proven its case beyond a reasonable doubt as to every element of the offenses charged here, and I ask that you find the defendant guilty. Thank you.
Thank you. Mr. Jordan?
Buckle up, here we go. This whole defense is on his phone.
Ladies and gentlemen of the jury, just want to start by just thinking out loud. Because if the door was one that was so rigged that's been repleted and included in the closing argument, I do believe there would have been pictures taken of a rigged door supporting any claim that would be stated as such. But nonetheless, again, ladies and gentlemen of the jury, I do again stand here before you today seeking the extended hand of justice. Prior to this claim, prior to an officer obtaining a legal warrant, law enforcement did in fact search my home, as well as allow individuals who were not residents to remain in my home as I sat in a police cruiser. And may I remind you that no crime had been committed, and that the true reflection really is to what extent of constitutional violations in order to create such a crime. Because of the illegal search and seizure, the prosecution has presented to you evidence in which at face value, some would assume to be a crime. But because of my 4th, 5th, and 14th Amendments rights being compromised, I was not afforded a due process of law, as well as an attorney who sought justice as I did. I urge for you to simply consider what is fair and what is just. Because of these violations do not only affect me, but they do have a greater impact upon society, meaning all citizens, as well as the integrity of the legal system at large. Again, ladies and gentlemen of the jury, I urge for you to consider the evidence in light of constitutional violations, and once more I urge for you to render a verdict that respects and reflects legal rights, our legal rights and principles of justice. And thank you for your attention.
Thank you.
Whoa, short and sweet.
Thank you, Your Honor.
Doesn't deny anything. Just says,
good morning, ladies and gentlemen of
right.
the jury. When Ms. Lewis-Gunnell testified yesterday, I think she perfectly summarized the events leading up to this. This was an escort gone bad. As Ms. Wood stated, and as you heard over the last couple days, there was a lot of chaos leading up to the events that happened here. It was a chaotic scene, And as a result of that, you heard from a lot of witnesses over the past couple days, and we appreciate your time and attention in listening to those witnesses and everything they had to say. I know it may have seemed tedious at times, but it was important. It was important for the state to prove, for you to hear that evidence in order for the state to prove each and every element of these offenses beyond a reasonable doubt. And despite that chaos, despite everything going on scene, what you are asked to do today is very straightforward. You are here to determine if the defendant knowingly had a firearm when he wasn't allowed, if the defendant knowingly possessed or used cocaine, and if the defendant knowingly solicited another to engage in sexual activity in exchange for that person receiving something of value. Briefly, I want to talk about the having weapons while under disability counts. The defendant can be convicted of both of those counts. It is charged alternatively, so that if you find that the state has proved each and every element of those offenses beyond a reasonable doubt, you can find him guilty of both of them. If you find him guilty of one, that would not preclude you from finding him guilty of the other. I just wanted to make that clear. Sometimes that can be confusing. Here, for both counts, we're talking about the same facts, the same gun, the same night, and the same prior conviction. To address what the defendant came up here and stated, this is my full circle moment when I bring you back to what we talked about in voir dire Tuesday morning, these collateral matters, things that are not elements that the state has any burden to. The search of the defendant's home is a collateral matter. The constitutional alleged violation, that's a collateral matter. Even to consider what is fair and just, that is not what you are tasked with here today. As we talked about in voir dire on Tuesday, the state has no burdens as to these collateral matters. Any alleged violation of the defendant's rights or unlawful search, those are matters of law. That is Judge O'Donnell's job. That is not your job. And the jury instructions that the judge provided you, you will see nowhere in there are you asked to decide those matters. You are asked to evaluate the evidence and apply the law and determine if the defendant knowingly possessed a gun or knowingly had a gun, knowingly possessed cocaine, and knowingly solicited Ms. Thomas and Ms. Lewis-Gunnell for sexual activity in exchange for money. I want to talk about this kind of in reverse chronological order, talking about the soliciting first. You will see in the jury instructions you were provided that the law does not require the sexual activity to actually have occurred. All that the law requires is that the defendant knowingly solicited the women to engage in sexual activity. And Ms. Thomas and Ms. Lewis-Gunnell both testified that they were solicited to come to the defendant's apartment by the defendant to engage in sexual activity. Both testified that they were there for a two-girl special.
Often referred to as buy one, get one free.
Ms. Thomas and Ms. Lewis-Gunnell's testimony differed as to whether or not sexual activity was actually performed in that apartment. But again, the law doesn't require the state to prove that sexual activity would have occurred. And it is up to you to weigh and determine the credibility of each witnesses. Why might Ms. Thomas not want to say that she had performed fellatio on the defendant? Could she have been embarrassed? It's for you to decide. But Ms. Thomas and Ms. Lewis-Gunnell, they didn't know the defendant. They had never met him before. They had no motivation to lie here. In fact, they told the truth to their detriment. Both women were arrested that night and convicted of engaging in prostitution.
Object, Your Honor.
Overruled.
You should object to that.
On scene, Both witnesses were telling officers and testified here today that the defendant had a gun in his apartment. Both women testified the defendant was smoking crack from a crack pipe in his apartment. When the Willoughby Police Department obtained a search warrant and searched the defendant's apartment, they found the firearm and the crack. And not only did they find the drugs that the defendant was smoking, they found them in the exact location where Ms. Lewis-Gunnell testified that she saw him grabbing them from. In State's Exhibit 10C, it was on the shelf and that kind of makeshift headboard behind the defendant's inflatable mattress. When officers asked the defendant for consent to search his apartment that night, he wouldn't give it to them. We heard from Kelly Reese with the Lake County Crime Lab, who analyzed the DNA in this case. And the DNA here on the pipe was a match to the defendant. She testified that it was a very strong association, and she also testified that the defendant's DNA was located on the firearm. And not only was his DNA located on the firearm, scattered throughout his apartment were magazines, ammunition, and boxes of ammunition. Ladies and gentlemen, we are here to focus on the actions of the defendant, not the actions of law enforcement and not the actions of Ms. Lewis-Gunnell or Ms. Thomas. It is the actions of the defendant and what the defendant did on June 20th of 2024. The state has proved each and every element beyond a reasonable doubt, and we'd ask that you find the defendant guilty on all counts. Thank you.
All right, so just shy of 9:30.
Ladies and gentlemen, we'll pick back up on near the bottom of page 11 if you want to follow along in the instructions.
Our time, it looks like 9:09 there.
The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the other instructions. The court has instructed you on all the law necessary for your deliberations. Whether or not certain instructions are applicable may depend upon the conclusions you reach on the facts. If you have an impression that the court has indicated how any disputed facts should be decided, you must put aside such an impression because that decision must be made by you based solely on the facts presented to you in the courtroom. You may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Circumstances in the case may arouse sympathy. Sympathy is a common human emotion. The law does not expect you to be free of such normal reactions. However, the law and your oath as jurors require you to disregard sympathy and not to permit it to influence your verdict. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. When you go to the jury room, your first function will be to select one of your number to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than any other jurors. He or she serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and any exhibits are returned to the court.
There goes our audio.
You have reached a verdict. If you took notes during the trial, you may take the notes to the jury room. The fact that notes taken by a juror support his or her recollection.
Okay, we're going to fast forward because we can.
His or her memory more reliable than that of jurors who did not take notes. All notes will be returned to the bailiff for destruction when the jury is discharged.
we're fast forwarding here. The jury is going to be dismissed. They go out and they start
the jury drive all of the admitted exhibits to go back to the
deliberation.
Jury. We then had court IT, Deborah Urankar, come down and assist us in, actually she performed the function on the computer of locking the jury drive to be read only, so that there may be no deletions or changes to the exhibits on the jury drive, and we would just ask that the court retain both of those at the conclusion of the case.
All right, and the jury drive is where?
Is right here, so they will need a computer to observe.
And they have one. Okay. So when Mr. Gonzalez comes back, give him the, or actually give it to Kathy right now. Okay, the drive.
Okay.
Okay.
Judge
Anything
instructs
else?
the jury, says, when you're reviewing all this evidence.
The court intends to send the firearm and ammunition all back with the jury.
The lock is on the firearm, correct?
Yes.
Yes, I do.
Okay.
They will go back to them.
They have coke.
Anything else, Mr. Jordan?
They have crack. They have a pipe. They have a gun. They have ammo. The jury has everything they need to deliberate, but the judge tells them, if, as you're reviewing all the evidence and the testimony, it arouses any emotion of sympathy for the defendant, please disregard that perfectly natural reaction. But you can't consider that. You can't consider that in deliberations. Phrasing, Judge. Phrasing. All right. Coke and crack to the jury room. Pipe, everything. Yep, it's all going back. There she goes. Yep. Pipes in there. Cracks in there. Just making sure. Judge knows what he said. 2 snow trials in a row. Yes. So jury's going to be deliberating. We're going to jump to real time because we can. And we're still waiting. We're awaiting their return. We also are waiting for the trial to start in Ohio, which is slated for about half an hour from now. So we get just a little bit of time. The jury's been deliberating approximately for 20 minutes at this point because we were a little behind. What if they're going to test it? No, they just have to take the words of the lab. They don't get to actually try anything in the evidence box. Yeah, I know it's a bummer. You thought there was a perk to being a jury, but no, there's not. No perks. Can we get an intro to this other trial? Yes, Kaylee, the other trial. This is what we're calling the Snowplow shooter case, not murder case, because despite what the state says was his best efforts, he failed in the murder part. He succeeded in the shooting but failed in the murder, only ended up permanently injuring the victim. The victim, according to the state, the defense says that the victim was actually the shooter because he felt threatened by the words said by the victim, which was basically, if you push that blanking snow in front of my blanking driveway again, I'm going to blanking kill you and your family. Those words, only he substitute blanking for the bomb. And so after the guy threatened him and started headed back to his house, he pulled out his firearm and shot him once in the jaw, which dropped him to the ground, and then shot him 5 more times on the ground just to make sure, because, safety. And it's all on video. And it was witnessed by 2 teenage daughters, one on each side, 18 and 19-year-old. And the family members were present very close. So wait, there's video of this? Yes, Kaylee, there's video. It's not the best video, but there's video. So, yeah, it was. It's bad neighboring, is what it is. It's somebody who failed in the neighbor department. Most people, they just take cookies to their neighbor, or even volunteer to shovel clear their driveway. This one, they shoot each other. So. Did get another delivery today. This is 2 I'm telling you what these are. Not that you asked, but 2 1/8-inch audio, sometimes referred to as an aux cable, AUX. Need these to connect different devices to transfer audio from one device to another. And so we'll add that to the list of ever-growing cables. And I think I was going to tell you, I did order, and I put the link in chat, I did order some evidence, copies of evidence for the Brian Koberger trial, which is coming up. I determined that I don't actually need to order the actual K-bar knife. First of all, because they run depending on which, if you get the stainless fancy one or the, just the plain one, between about $100 and $300 for a K-bar knife with a U.S. Marine Corps knife sheath, like the one that is alleged to have been in the crime scene for the Koberger killing trial. I ordered just the sheath, and then I also said, well, it's not going to do any good unless I also have the knife. So I ordered a dummy K-bar knife that fits the knife sheath. So it's a plastic version of the K-bar. It's called a trainer. They use it for like fake knife fights for police to learn how to disarm and dodge and everything else. So we have those coming. It'll be here by the weekend. That'll help us visualize what they're talking about during the Koberger trial. And it's not a sus order at all. I think it's normal for people to order crime scene evidence. So you can order evidence. If Walmart has a murder aisle, Amazon can have a crime scene evidence section. So, how many buttons on the sheath? There's just one. It's a very this knife. Interesting fact: the K-bar knife is one of the most popular knives in the world. It's one of the most recognizable knives in the world. Think of it like a Rambo knife. Sometimes Rambo had like a fancier version, but yeah, a K-bar was a military knife that was very, very common, and you can find versions of it all over the place. I have heard about this video. Let me do this. If I can find a YouTube video, just anyone's YouTube video that has that, we can work on this together while we're waiting for court to start. So let's do this. Let me go right here. We'll be back. We'll be back in just a second. And search for new bridge guy video. I hope that pulls up. I said guy. Oh my goodness. Whoa. Pronunciation is important. New bridge guy video. No, it auto-corrected again. That is not what I'm searching for. That was not it. I'm going to type this one in. Yeah, we're about to see something. New space. Bridge, B-R-I. I'm using a remote. D-G-E. Guy. G-U-Y. Video. Okay, full bridge guy video release. I'm just trying to find who has a good, clean copy of this. It looks like we can get it from WTHR. Let me see if we can pull this one real quickly.
Thanks for.
I don't want to hear their intro. Okay, they're just doing a wrap up. I need full bridge guy video. Hidden true crime. Let's see if you'll play it for us here. Hoping she doesn't talk over it. Or if somebody has... Hey, Kaylee says, I just texted you the short of video only. That would be great. Kaylee, just 1 second. Grizzly posted a link. Awesome. I should probably check that first, because I'm trying to grab it from somebody else, and that doesn't work very well. Okay. So Grizzly True Crime has just the video, right? Okay. Grizzly, thank you very much. That is fantastic. If you don't mind, I'm going to use that to try to do a little bit of audio work. Okay. Grizzly True Crime. Here we go. All right, we're going to jump to, you guys can watch this. Here we go.
See, this is the path that we go down. There's no path going there, so we have to go down here. Hi.
All right, that was it. That was it. Let me pull this in on our little editor and see what we can do here. All right, let's jump to, I'll show you this one. There we go. Let's play with this editor here for a second. Okay, we're going to be right here for the start. Rewind to the very beginning, and right here, there's our first frame. Set our endpoint and run it.
See, this is the path that we go down. There's no path going there, so we have to go down here. Hi.
Okay, now we dump that into our timeline. And where's my mouse? There it is. We'll put that down on our timeline. Now we'll go to edit and play with the audio really quickly. Want the whole thing. And on the audio section, we're going to see if we can do some voice isolation. And bring up the dialogue to lift soft dialogue a little bit and crank our volume. And it's going to be right down here. Let's see this part. It's definitely guys down the hill. But the voice isolation is too steep. We're going to take that down to about 70%. More lift for low levels. Actually, we're going to bring up soft and whispery sources instead. Let's try that again. I hear guys down the hill. Guys, hi, down the hill. Let's jump back just a little bit to when we see the guy behind them on the tracks, which was right back here. Okay. And let's bring in the video so we can zoom in and see what we can get out of this one. Not seeing before this. Okay, right here. Hands in pocket, windbreaker, jeans, dark colored shoes. The way they say hi, it doesn't seem like they were together. Like, what does that say? Let's listen to the whole thing with the audio cranked up a little bit. Okay. Let's turn off the voice isolation. Or turn it down. We want to hear everything. It's going to be loud, sorry.
See, this is the path that we go down. Path going there, so we have to go down here. Hi.
Do you guys see more shadows? I'm trying to look for people's shadows on the ground. Sorry. What's the first thing they say? Sorry, my chat is on the opposite side of when I'm editing, so I can't see what you guys are saying here. Let me remove this pin. Make sure we go back and don't miss the verdict when that comes in. There we go. Okay, so we're still waiting on that. I'm looking at shadows. The sun, if you look at the ground right here, the sun is coming from our back left corner, right? If we're the camera, it's coming from behind us and to the left. So we have some shadows on the ground. Roll through. What is that? That's a tree in the bottom right-hand corner. Back to the beginning. The whisper right here at the very beginning. Let me see if I can isolate that because it's so quiet. Let's take the lower end out because we don't want that. Frequency, let's crank this on. Try to get rid of the train noise just a tiny bit. Okay, let's try that again. Let's go back again. We need more volume. Okay, I think what's happening, the girl on the bridge, it says something, right? Right here, watch. Right back here, watch what she says. Watch her mouth as she looks up, head comes up. Is he following? Is that what I'm hearing? Is he following? Is he following me? Is that what you guys hear? Is he behind me? Is he behind me? It's definitely a is he something, but then it sort of trails off on the back end. Let's zoom in on her mouth, see if we can give us any clues. Oops, let's reset that one. Let's get nice and tight here and watch the top part of the screen. Let's put her right in the middle so we can watch this. Let's see. What kind of stabilization can we do? Perspective. Watch the face. The last word looks like he is like more like a U.
Voicemail, press 2.
Hey, this is Scott. I missed who the name is. Who's this?
I said the mods are trying to get your attention in chat. This is Tisha S.
Hey,
Hi.
Tisha. How you doing? What's happening, Tisha?
I'm good. How are you? Oh, I don't know. I just see that the mods are trying to get your attention, and Buffer's not working, and they're all crying, so I thought I'd call.
Oh, let's see. Okay, I'm looking. I don't see it. I don't see them trying to see it.
Okay. Well, Josh and I don't know. Why are y'all not wanting his attention now? Now that I got him on the phone. Yeah, Josh said 3 of the mods have tried to get his attention. So I was like, okay, let me try to call. I don't know what's going on.
Okay, I see that. All right. Thank you very much. You have my attention, mods.
You're welcome.
There's a better.
Okay, yeah, you're welcome.
There's a better video source. Okay, awesome. Thank you so much, Tish. I appreciate it.
You rock.
Right, bye.
Bye.
All right, sorry. I'm zoned in right now. But let's do this. Let's slow this down just a tiny bit. Mods, I've turned up the buffer sound. Oh, I muted it. Sorry, it's unmuted now, so you can buffer me now. I don't know why I muted it. Let's change the speed just a tiny bit. That's going to be on. Let's do that. Let's try to keep this here. See if we can put her on the. Okay, let me check the mod chat. Sometimes they send me stuff. We've got the actual download of the file apparently. Okay, let's do this. How do I download that one? Give me the file. I need to switch my phone over to my computer. Let's see how this works first. Hang on 1 second. Let's rewind a tiny bit. It's not liking the stabilization on top of that.
Call from Lisa.
Hey, Lisa. How are you doing?
Good. Hidden True Crime did a good video on this, and if you turn on the closed caption, it'll tell you what they're saying.
Yeah, I'm going to do my own, though. Is that okay?
Sure. Oh, yeah, of course. It's your channel. But I was wondering if you consider turning on the closed caption just for this one video.
We can't because of how we live stream. We live stream with almost no delay, and closed captioning takes a long time to process, so it does not work for our channel.
Oh, does it?
No.
Oh, okay.
All right.
All right.
Thank you. All right. Bye.
Thank you. Bye.
Okay. The last word, she says like a U. Her mouth is in a U shape. See if we can adjust the speed here. I'm not sure where I put that one. Speed change. Here we go. Let's turn it down a tiny bit. She breathes. Let's see if we can cut that audio out. It's going to be loud, so I apologize. Apologize for your eardrums in advance. Sometimes we do this. Now let's see if I can take the noise out a tiny bit more.
is the path that we go down. There's no path going there, so we have to go down here.
All right. We played with it a little bit. Going to turn that down, just turn that up just a tiny bit. Crank the volume. Guys, down the hill. All right. Looks like people at the end of the bridge, too. I didn't see any people at the end. Let me reset the volume so we don't blow our eardrums out. Okay. If we scroll through nice and slow, see if we can get some frame grabs here. Let's zoom in. Might try to get a better copy of the video up for that one. Okay, we're going to play it. We're going to play it from my phone directly from the website that released it, which was his defense team. Looks like this. Let's back up. I had the volume off. Sorry. Amateur move.
See, this is the path that we go down. There's no path going there, so we have to go down here. Hi.
Man. I don't know. That's, they got it from her phone, which she found. Yeah, the raw file is much clearer. It just takes a bit to, it's not as easy for me to get that to my recorder. All right. Well, it is what it is. Can you not pull up the site on your PC? Yes, but I need to get it into SDI to record it, which currently is connected to my Apple TV, which does not like to go to that website. So people have recorded the main one. Let's see how I can do this on my computer. Let's go back to cut or maybe media. Okay, we're trying to get there. Just 1 second. Have we started the other trial yet? Is New Hampshire, is it beginning right now? Do you have to jump over there? Okay, let's get ready to go over there. I'll keep working on this on the back end. Updates, transparency. Oh wow, hang on. Download. There it is. Now we'll drag this guy into our editor. Okay, so now we're going to watch it all in as highest resolution as I can possibly do it in, which is right here. You guys ready? Let me get this off the screen. One time through all the way.
See, this is the path that we go down. There's no path going there, so we have to go down here. Hi.
Man, the whispers from the girl with the camera. I don't see that. I think it checks out that it's from the girl on the track. Cause look, watch the girl on the tracks. She's got her head down, and when the whisper starts, she looks up and starts whispering. Yeah, the mouth moves, the facial expressions. You can see it all right.
See, this is the...
Yeah. All right. We are about to go to court in New Hampshire, so let me get that set up right now, and then we'll watch for... watch for an update out of John P. O'Donnell's court as well. Give me a second to get everything configured. Box 2 is... Still working here. Sorry, guys. Hang on. All right. As we're about to jump to court in New Hampshire, this is the Snowplow trial. We're going to keep an eye on the John O'Donnell court as well. Let's see, what do we keep down here? That's going to be 2. Okay. And our background is going to be blue. There we go. All right. Thanks for your patience, everybody. Getting everything set up. You had a couple chats here that I missed. I apologize for that. It looks like Greeners was hitting the like button, paying people to do it. Lois Cox paid as well. Thank you. Both clicking the like button and paying. Ulala Pat, member for 16 months. Welcome to the jury. Thank you very much, Ulala Pat. I sent you an email with sound file with voices isolated. Thank you. I'll take a look at that. There's not a lot. The problem is if there's not anything to work with, it's hard to create something. So I can crank it up, but I mean, it had to have been recorded for it to be found. So I'll check that out and see. Sloth Life, longer than my first marriage. I'm winning in life, 14 months. Thank you very much, Sloth Life, as an attorney. Thank you. Queen Olive, Ruth Ann, member for 26 months. OG. Whoop, whoop. Thank you very much, Queen Olive. We've got KP Jeep, member for 1 month. Woot, woot, as well. Welcome to the gallery. Thank you very much. All right, we're about to begin court up here in New Hampshire, if we can get everything working right. Let's see, everything's live.
Which essentially would have made it more difficult for us to plow by hand. So he went out to ask.
We're a couple seconds behind. So here we go. Judge walking in.
We ready to bring the jury out? Yes.
Please rise for seating of the jury panel.
Someone's plugging in their USB devices. I'm going to end the poll on the Jordan guilty. 70% say yes, guilty of all charges. 11% say he should have been charged with more. Queen Olive, thank you very much. Appreciate that.
Please be seated. Good morning, ladies and gentlemen. I hope you all had a nice evening. I want to start by thanking you all. My people tell me everybody was here right on time. We're greatly appreciate that. So thank you very much. And now we're ready to proceed. Attorney Barth, you ready to call the state's next witness?
I am. Angela Violet.
Very good.
And the witness stand in this courtroom is up to just to the left of the judge. If you could approach the witness stand, face the judge, and remain standing for your oath, please.
Bite me, OG. Thank you very much.
You raise your right hand. You swear to any testimony you're about to give the truth, the whole truth, and nothing but the truth under the pain and penalty of perjury.
I do.
You can be seated right there. Please do me a favor and scoot up to the microphone.
Sure.
Okay.
Hi. I made my first mistake of the day and calling you as Angela Violet. Could you state and spell your name for the court record, please?
Angela LaChance, first name Angela, the last name is Lachance.
I want to ask you some questions about your relationships, and I understand that your last name is not Violet. This is LaChance, but who do you consider yourself with?
Kyle Violet.
How long have you guys been together?
22 years.
And do you have a family together?
We do, 2 children.
Can you give me just their ages?
My son is 15, my daughter is 18.
And I don't think we need to get in too much to your son. My understanding, he did not witness directly events here, but we met your daughter yesterday.
Yes.
What's her name?
Kendra Violet.
Okay. And where do you guys live?
43 Summer Street, Rochester.
Who do you live there with?
Kyle Violet and our 2 children.
We had heard yesterday.
We heard something yesterday. What was it? Now's a great time for the court to turn the audio system back on. But they haven't. Somebody kicked a cable. The cameraman sat down, yanked the microphone cable out of the camera. Okay, there's our other court in the bottom right-hand corner. We're going to keep an eye on that one. Still waiting for audio. There it is.
How's that working out for you guys? Too much time together? Or?
No, it's great. Actually, no, it really is great. She's a great kid. I love working with her.
Look, Angela, may I call you Angela, or would you prefer Miss LaChance?
No, Angela's fine.
Thank you. You know why we're here, why you're here today, and I want to now focus on April 4th of last year. Can you just begin and introduce us to what was going on earlier the night for you and your family?
Sorry. We were all off, well, myself and Kendra were off of work that night, so we were just kind of having a family night. We had made dinner. We had all retired up to our bedrooms. It was about, 10 o'clock or so. Myself and Kyle were in our room. Kendra was in her room. My son was in his room playing video games.
Okay. Tell us a little bit, I think we know, but what was going on outside?
It was snowing.
All right. And not just snowing, right? This was a pretty big storm.
It was a pretty big, yeah. The biggest storm of the year, I'm pretty sure.
What was your plan, and not to get too far in the weeds of this, but what was your plan for clearing the snow from your driveway?
My daughter's friend, her father plows, and he was supposed to come plow our driveway. We were going back and forth between text messages for quite some time, and he didn't show up when he said he was going to show up. And quite a few hours had gone by, so I really didn't think that he was going to show up. So our plan essentially was going to be to have to go out and shovel by hand.
All right. Plan B, shovel by hand.
Yep.
Create some degree of anxiety, concern among everybody?
Yeah, of course. It was a lot of snow.
And did you need to use cars in the morning?
Yes. Yep.
Who lived next door to you, I guess as you are facing the house to your right?
Jason Levesque and his parents.
And you said that there was kind of a plan A for your plowing and then a plan B by hand. Look, had there been any concerns about the volume of snow out front?
Well, yeah, the snow piles up from the plow going through the street, and then it got built up even more by Mr. Levesque.
And so, had that been an issue prior to this night?
Yes.
In what way? How can you describe how you've seen the process work before?
He would plow his snow from the front of his driveway past our telephone pole, build up pile in front of the street and then push it in front of our driveway.
Okay. And you say there would be a pile near or just beyond the
telephone pole. Yeah.
And was that a first step? And then what followed? And then what was the second step?
He would, because obviously he can't leave it in the street, he would ultimately push it at the end of our driveway.
Okay. And did that include the snow that was then backpulled out of his driveway?
Yes.
And had that been a, tension point prior to the 4th?
It had happened at least one time before.
Okay. You were just talking about a family night moving towards, sounds like, closer to bedtime, with people dispersed in your home, doing their own thing.
Yeah.
What happened after that?
When we realized that Kendra's friend's father was probably not going to show up and we were going to have to plow by hand, Kyle noticed that Mr. Levesque was plowing his snow to the end of our driveway, which essentially would have made it more difficult for us to plow by hand. So he went out to ask him not to do that.
Can I ask you to provide kind of a sequence of events where you went to?
Yeah, so after he grabbed his hoodie, he went to walk out. I went into Kendra's room. I said, your dad just went out to go talk to the neighbor. Me and Kendra walked downstairs into the living room. We were kind of just walking around the living room. And then we went to the bay window next to the screen porch where the video camera is.
Understood.
And we were looking outside.
So this may be obvious. We were out there yesterday, I think you know, and you're describing there were 2 bay windows facing your house from your driveway. Are you talking about the one to the left or to the right?
If you're facing my screen porch, it's to the left.
If you're facing the screen porch.
If you're facing my house.
Then it's the first one to the left. Okay.
Yeah.
And you said you were both looking outside from there, and there was a surveillance camera from a similar angle. Is that fair?
Yeah, so the surveillance camera comes from the top left-hand side of the window, and myself and Kendra were just, looking from the middle. Kendra was on the right.
After the events occurred outside, did you have contact with law enforcement, any police officers?
Yes.
Did you agree to provide the surveillance footage from that camera to law enforcement?
Yes, I gave it to them that night. I provided Kyle's phone because our cameras are on an app that was on his phone. We couldn't get onto the app on his phone, so I emailed it to them. I airdropped it to them. I provided multiple different ways of them having that video.
And that night, did they come inside at some point after this event and actually view your phone?
Yes.
Are you aware whether or not they actually then took a screen video of your screen video as well for short term?
Yeah.
Okay. Look, I don't want to gratuitously do this, unnecessarily do this, but we watched that video yesterday, and I want to play an abbreviated version. I don't think we need to go through the whole thing.
Sure.
I'll certainly defer to the defense, but I want to show you a portion of that because I have some follow-up questions for you.
Okay.
Okay? Bear with me just a second, Your Honor. May we set up? We managed to upgrade. Okay, we moved it.
Oh, yeah.
Yep.
I say we've upgraded, but I don't know that actually works.
And Your Honor, for the record, this is State's Exhibit 2 as a full exhibit.
Yeah, thank you.
Judge, this will just take a minute. Your Honor, with the court's permission, may the witness leave the stand and approach the well.
Once you're ready.
Yep. This voice seems to carry fairly well, but I'm just going to bring this down. And holding my breath.
Wow, that was loud.
Angela, do you recognize this image?
Yes, that's the image from the surveillance camera in my bay window.
Thank you. Counsel, can we play and spare? I don't know that everybody needs to see the plowing again, but perhaps when Mr. Violet leaves the residence.
Get the reflection of the clock right in the middle of the screen in the area that we'd like to see. The clock is inverted. Good catch, Red Pen.
And can you identify this person?
That's Kyle.
You had described him putting on a hoodie. Did you see him do that?
Yes.
If I could stop there. Are you able to see Mr. Levesque's truck door open in the left corner adjacent to the house?
Yes.
Okay. And you had just said, there he goes.
Yep.
Who are you referring to?
I'm referring to Jason getting out of his truck.
All right. And can I have you continue? Can I pause it here? You just said, I hope he doesn't do anything stupid.
Yes.
Who are you talking about?
Mr. Levesque.
And are you able to hear from your, I guess, vantage point, the conversation or words exchanged, if any, between Levesque and...
No, we were not able to hear anything.
Okay. Could we continue to play? We stop. Can you tell who it is that backs away or separates from the truck?
In which part?
This part here, the individual on the right, to your knowledge, is...
That's Kyle.
Okay.
That I can see right there by the pole.
All right. Please.
No, he's getting up. He hasn't gotten out of the jail. Hey! He just got him! He just got him! Hey!
Rewind just back to approximately the point where she indicates he has a gun. Pause, please. You yelled at about this point that he has a gun.
That was Kendra.
Kendra,
yeah.
Were you able to see a firearm?
So when Kendra noticed the gun, I was walking towards the window, but I was looking down. When she yelled, "He has a gun," I looked up and I witnessed the first shot to the face.
Could you tell that he had a firearm in his hand?
Yes.
And was there anything about the lighting or the distance that prohibited you from seeing what he had in his hand?
Nothing at all. I had a very clear view.
Were you able to see whether Kyle had anything in his hand or brandished anything in his hand during your period of observation?
No, Kyle never brandished anything or had anything in his hand.
And can you roll this?
No, he's getting up. He hasn't gotten out of the jail. Hey! He just got him!
Can you pause it? What direction was Kyle proceeding in when the first shot was fired?
Kyle was starting to walk home.
And the next 5 shots, were you able to tell what direction he was proceeding when they were fired?
Kyle was already on the ground from the first shot.
And his movements, in what direction did he go?
He was trying to army crawl home.
Can you just proceed? Who is this?
That's Kendra.
And who is this?
That's me.
I think that's good. Ma'am, could you resume the witness stand, please? May I proceed, Your Honor?
Yes,
please. We just left off where you went outside. Can you describe how Kyle appeared to you when you reached him?
When I went outside, he was curled up in a ball by the telephone pole, bleeding profusely. I called 911 immediately.
What's your estimate of how long it took for law enforcement to respond?
Only a couple of minutes. It was very fast.
And from there, can you just briefly describe to us the sequence of events as you experienced it?
Yeah, one of the officers started rendering aid while the other officers took Mr. Levesque into custody.
And when you say rendering aid, did they render aid at the scene, at that location?
Yeah, I believe one of the officers ripped his shirt off. They had to turn him over onto his side because he was choking on the blood from the first shot to the face.
Were you there for that?
Yes.
And can you just confirm for us that Kyle was taken from the scene by ambulance to a local hospital?
Yeah, first he was taken by ambulance to Frisbee. I met him there.
And can you just describe for us the sequence of events and what happens next in terms of...
I couldn't get my car out of the driveway, so I had to call one of my coworkers who came and picked me up, and she brought me to Frisbee. They immediately let me back into the room where Kyle was. They had taken off most of his clothing. They had to cut it off. He was not conscious. He was still alive, but he was not conscious. They told me that he had lost a good portion of his blood and that they were...
I just have to object to what you were saying. But I understand the objection, Your Honor. I'll rephrase and focus. When I'm asking about the experience, it's not necessary, and other witnesses would have to provide the actual assessment. And so I'd ask you not to convey through hearsay what the doctors told you.
Oh, sure.
I just want to get a sequence of your experience. Where did you go? How long were you at Frisbee?
He was not I couldn't tell you exactly how long we were there. It was not very long. He was transported to Portsmouth shortly after.
What did you do from there?
I went to Portsmouth. I had my coworker drive me to Portsmouth.
And were you able to see Kyle at Portsmouth?
I was not able to see Kyle at Portsmouth because he was in emergency surgery.
And how long, in your estimate, and again, I don't need to hold you to an exact, but how long do you think you were at Portsmouth?
Maybe a couple of hours.
And what happened next?
They took him to Boston Medical Center.
Do you know how he got down there?
Yeah, by ambulance.
And what did you do?
I went home to check on my children because they had stayed home. And then I went to Boston.
And how often were you able to see Kyle in Boston?
I stayed with Kyle in Boston from the day he got there until the day he went home.
Approximately how long was he admitted to the Boston facility?
April 5th to May 1st.
Your Honor, with the court's permission, I'd like to approach. We submitted the medical photos. With permission, I'd like to approach, show this witness what's been marked as State's Exhibit 19 as a full exhibit. Counsel is 260 discovered.
Let's double check. You have no problem. And that's okay.
Thank you.
Very good, thank you.
Angela, I'm going to show you a photograph from that time.
Says I'm going to show you a photograph from that time. Your document. It's a photograph. Do you recognize it?
That's Kyle.
Is that a fair and accurate depiction of how he appeared?
Yes.
Your Honor, can I ask the court to indulge me and remind the jurors that they'll have full access to any exhibits that are here?
Yeah, I'm about to do that. So while you take your time looking at it now, understand you'll have an opportunity, any full exhibits you'll have an opportunity to see them later in the jury room. Thank you. Go ahead.
Thank you. Angela, you said he was, released from the hospital. What was for instance, his last medical appointment related to these events?
The last medical appointment he just had was in the beginning of March, and he just went for a CAT scan it was Tuesday, I think, Monday or Tuesday? Monday.
Remember where Kyle was working before these events?
Yeah, he was working at Aldrich Lumber in Portsmouth.
Doing what?
He would it's not a mill yard where they make the wood, they sell it. So he would stock the shelves, help people if they came in to buy the lumber, load their trucks, stuff like that.
Been able to return to work?
No.
Physically, how is he today?
Still recovering.
And can you describe kind of his mental state concerning these events now?
He certainly is not the same person mentally that he was before this happened. He has severe PTSD. He's very depressed. He has a lot of anxiety because a lot of paranoia.
Is he still at home with you?
Yes.
No, for just 7 minutes. Angela, this may sound like a strange question, but there's some legal obligations on my part. But I need to ask you, are you able to identify Jason Levesque in the courtroom today?
Yes, he's right over there.
And could you please identify him by some description of clothing or his appearance?
He's the man sitting right there with the dark beard, with the gray suit on and the blue undershirt.
Thank you. Your Honor, may the record reflect that this witness has identified the defendant as the individual depicted in the images that you referred to.
Focus.
Angela, those were my questions. I appreciate your time. As you know, Attorney Sisti will likely have some questions for you as well.
Sure, thank you.
If I may, Judge. Yes.
few questions.
Sure.
And nobody wants to put you through this kind of stuff. You understand that, right?
Yeah, I do.
Okay, good. Prior to this date, did you ever have a conversation with Jason?
I had never spoken to that man ever.
Correct. You'd never spoken to that man ever, and he has never approached you before that date, ever.
No.
I think I may be having a technical difficulty. Yeah.
We don't want a technical difficulty.
Go back.
Bad way to stop a trial. I'm sorry, Mark. Tell us when you're coming.
Thank you. Sorry.
Okay, let's get back to it. You never had a conversation with him, right?
No.
He never had a conversation with you, right?
No.
He never had a bad word for you, right?
No, I never spoken to him before.
Yeah, right, okay. And how long were you there from the time you left Farmington?
At the time of the incident, it was 2 years we were living there.
And again, I don't know if I heard you right. Was there a particular reason you left Farmington?
No, we just got a new place. It happened to be in Rochester.
All right, even though the kids were comfortable in the school, you wanted to go to Rochester, is that the deal?
Yeah.
On that particular night, actually, I think you may have made a little bit of a mistake, but I don't want to get too technical. It actually wasn't snowing at the time, at about 10 o'clock p.m. on that night, correct? Snow had stopped.
I'm not really sure.
You're not sure? Okay. I want to make sure that we're sure of a lot of things here. Okay. Actually, let me ask you a kind of a goofy question, I guess.
Sure.
You were having problems and anxiety about your driveway being plowed?
Yes, my daughter's friend, father was supposed to come plow us out with his plow truck.
Okay. And you all had to get out in the morning and you were concerned about that?
Yes.
And you were actually kind of anxious about having to hand shovel the whole thing?
I wouldn't call it anxious. We were concerned that we were going to have to shovel by hand. Yes, it wasn't. No.
Well, you saw in the video there was a guy right next door with a plow, right?
Yes.
Did anybody have the idea that maybe you could go out and ask that guy right there?
Actually, my mother, who used to live in the front of our house, had asked Mr. Levesque one time prior when it snowed.
I'm going to ask you. Did you or Kyle have the idea that maybe you could go right next door because you were in some trouble and ask him to plow your driveway?
No, because he had refused it before.
To you?
To my mother.
So you don't know what happened there, do you?
I wasn't present, no, but she told me.
Okay, so let's talk about you and Kyle.
Sure.
Neither you nor Kyle had the idea to go over and ask him politely to just plow your driveway, right?
No, we didn't ask him.
Okay. And that idea never came up, or it never came up in conversation?
No, we never talked about it.
Now, at some point in time, around, I guess it was a little after 10 o'clock p.m., Kyle decides to go out to talk to Jason, right?
Yes.
And was he a bit perturbed?
He was, I don't know, a bit perturbed, I guess, that he was plowing the snow at the end of our driveway, yes.
Well, actually, you say that, but we're going to play that video again in a second, all right?
Yeah, sure.
We will. And the end of your driveway, of course, is on one side of the telephone pole, right?
Yes.
And on the other side of the telephone pole, there's no driveway there.
Yeah, that's where his porch, Mr. Levesque's porch is.
Right. In fact, the driveway itself actually isn't at the edge of the telephone pole. It actually starts about 8 feet in.
Okay.
Right? I mean, you live there.
Yeah.
Okay. I mean, I'll show you a photo if you need to see it.
Sure.
Okay. I don't want to be messing around. I want to make sure we're talking about the same thing. 294 in evidence. That's what makes you clear. I'm sorry. Can we have it? you what we've marked as defendant D for identification.
Yes.
Here's what is in which television.
That is the front of Jason Levake's house, and my driveway is to the left if you're looking at the picture.
Okay, is that a pretty good picture?
Yes.
Accurately show that?
Yes.
Can I have the ID spirit? No objection, Your Honor.
No objection, the ID spirit. What was it?
Before I show it to the jury, I just want to make sure we got this set up properly. We've got the utility pole, right?
Yes.
And the utility pole is basically right in the center of this picture.
I wouldn't call that the center.
Pretty close. It's on the side of your drive.
His house is in the center of the picture.
Okay. The pole is on the side of your drive.
Right.
Looking at the photograph, the pole is to the right of your drive.
Correct.
If I may close the pole. You may. I'm going to ask that the video be played a little bit in a minute, okay? But I want to be clear here. Levesque wasn't plowing your driveway that day, right?
He was not plowing my driveway, no.
And the Department of Public Works had plowed the road that day, right?
Yes.
And your concern was that they had plowed in front of your driveway, right?
They had already plowed in front of my driveway, correct?
Okay. And that was a concern because you got to bust through that by hand the next day if nobody comes to plow it, right?
Right.
Okay. And that was the concern that you folks were talking about just prior to Kyle approaching Jason, right?
Yeah, the concern was that he was piling more snow that we were going to have to shovel.
Okay, I want to be clear because we're going to see the video again, okay?
Sure.
All right. And we know which side of the pole, is what and where the driveway is, right?
Yeah.
And the photo I showed you is accurate as to where the driveway is, right?
Yeah, and you can see that the side of my driveway by Mr. Levake's house, the telephone pole is right by the end of that part, and we do park our cars there as well.
Again, that's fine. I'm not arguing with you at all, okay?
Mm-hmm.
But that pole's not part of your driveway.
No, the pole is at the corner of my driveway.
Right. In fact, there's a few feet before you get to your driveway from the pole.
I couldn't tell you exactly how far from my driveway.
Okay. Right. We're going to get to it in a second. So it actually wasn't snowing. You didn't ask Levesque to plow the snow. Your claim is that he was plowing snow into your driveway?
Yes, he was plowing some snow in front of my driveway.
And you are claiming that that's actually what you saw?
Yes.
Have you seen this entire video yet?
I have seen the entire video multiple times.
Okay, good. All right. Now, in that particular video as well, there is additional comments from you. Not only did you say, I hope he doesn't do anything stupid. And today you claim that you're referring to Jason?
Yes.
And you say, I hope he doesn't do anything fucking dumb.
Yes.
And today you're claiming that that has to do with Jason?
It does.
Did you tell the police that at any point in time?
Yes, I did.
You did? And which police officer did you discuss?
I'm not sure. I talked to so many.
Talked to so many. Well, let me tell you something, okay? Before you said those two things, you also said something, okay, as Kyle was crossing the driveway toward Jason. You remember what you said?
Yep, there he goes.
There he goes.
Yeah.
Who are you referring to there?
Mr. Levesque getting out of his truck.
He wasn't getting out of the truck.
The door had opened.
Yeah. We're going to play the video.
Okay, that's fine.
Again, you were asked by the prosecution as to whether or not you could hear any exchange of words out in the road.
Right.
And you claim you couldn't hear a thing, right?
No, I couldn't hear anything.
I mean, most critically, you certainly didn't hear Jason say anything, right?
I didn't hear either of them say anything.
Okay. So what happened out in that road? In any exchange, you would have no idea.
Not the words, no.
You wouldn't know if there was a threat, right?
I wouldn't know, no.
From your observations, did you see a young lady out there with Jason as well?
No, I did not.
We could set up to
I will get a bingo if while pushing the TV across the courtroom, it hits the cord and tips over and smashes on the floor. That's one of my boxes.
take it from the beginning where there's actual plowing taking place. And that's the jury. I'm going to ask you, can you
Best
mind
view
take
ever
over
right
too,
here.
so we're all looking together if we can.
Attorney Sisti, is it set up? I can't tell if you guys.
Yeah, I think you're okay.
Can all the jurors see? Thank you.
Ma'am, just so before we started, that dark mark across the center, that's just part of the window, right?
That's just part of the window, yes.
Okay, that doesn't indicate any kind of a clearance on the driveway or anything else?
No.
Okay, all right, good. If we could start the video, please. And I'll ask you a few questions as we're going, if that's okay. Okay. Did you see that at all from the window?
I wasn't looking out the window at this point when he was plowing.
Okay. Now, would you agree he's not plowing anything in front of your driveway, right?
Not at this moment, no.
Okay.
This looks like a regular type of snowplow. Not like a huge dump truck, but a plow truck. Now, to me, it looked like he was plowing from the house that's filming direction towards his house initially, or out in the street, clearing the street in front of his house somewhat. So he's pushed it away from their house. Let's see if he pushed it towards it.
Okay, we can stop it right there. Now, he did plow in front of his home, correct?
Yes.
And he plowed right up to the pole, right?
Yes.
He did not plow over to the other side of the pole, correct?
He was still actively plowing.
I understand, we're looking at this right now.
The edge of my driveway is shortly after that pole. Like I said, we utilize both lanes of the driveway, and my driveway starts shortly after the pole on the right hand side.
That is correct. And he has not plowed any snow on that side?
In this spring, yes, he did stop the pole.
Thank you. We can continue.
It's hard to see because that window bar is blocking the view.
Stop it right there.
Pushed it.
You did exactly the same thing, right?
Yeah, but I pushed the snow out towards my driveway.
It's not over your driveway, correct?
It is almost at my driveway, yes. My driveway is shortly right there.
My question is, it wasn't in your driveway, correct?
Not in my driveway, no.
Thank you. We can continue.
I think that's the furthest he pushed it.
Stop it right there. Again, that's not in your driveway, right?
No.
Thank you. We can go again. Now, were you looking out the window at this time?
No.
Okay. Stop it again. That didn't go in your driveway either, did it?
No.
Thank you. We can get it going again. Okay, so please stop. He's not plowing anymore, right?
No.
And who is going out through the driveway again?
That's Kyle.
Okay, can we back it up just a second? Is this when you looked outside?
No.
You did not look outside at that point?
No, me and my daughter were in the living room at this point. You can see the curtain move when you look outside.
I think we have a verdict.
Kyle go in the driveway.
I think we have a verdict. Hold on one second.
No.
Okay,
Right there.
okay.
We need to pause for just a minute because I think we have a verdict in this other trial. Let's listen in here.
So
Wait for just a couple seconds for it to come back here. If we have a verdict, I, of course, have to play the music. Wait for the audio. There's a paper from the jury. Might be a question. I think it's a verdict. What do you think? I'll have to play the music after because he hasn't told us.
All right, in the case captioned State of Ohio versus O'Shea Jordan, 24 CR 834, count 1, having weapons while under disability.
Whoa, we can't tell it yet. You start with a 2-for-1 deal on a list crawler, and you end up with 2 more pages on your rap sheet. At least that's what might happen here for Mr. O'Shea Jordan, who is finding himself facing a judge. A jury has returned a verdict in his case. He's been charged with a couple things. First of all, he was in possession of a firearm while under disability. That disability was a convicted felon disability. Also possession of drugs, which makes it another problem with the gun as well. And then, of course, there's the whole solicitation thing, where he jumped on what was it, list crawler, Gator Gals. What was it? I forget. There's like a million different websites that I didn't know about until earlier this week that you can order just about anything, except for what you can find on like Uber or any other store's normal menu. Yeah, you can order all the naughty stuff, and he did, allegedly. Ordered the 2-for-1 special. They showed up. Things went south. He smoked crack in his underwear on his air mattress, and now he's facing the judge. We've got a verdict here coming in right now. So here we go. We're going to turn the music down. Listen to this because we have to jump back to court in New Hampshire, in Ohio as well. So, or New Hampshire as well. I'm going to fade the music out. Here we go.
We, the jury, being duly impaneled and sworn, find the defendant O'Shea Lopat Jordan guilty of having weapons while under disability is charged in the indictment dated 3/13/25, signed by all 12 jurors.
Took an hour and a half.
Forfeiture specification to count 1. We, the jury, find that the state of Ohio did prove by clear and convincing evidence that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio. Signed 3/13/25, signed by all 12 jurors. Count 2. Having weapons while under disability. We, the jury, being duly impaneled and sworn, find the defendant O'Shea Lopat Jordan guilty of having weapons while under disability
as
charged in the indictment.
He got his 2-for-1 special right there. 2 guilties.
This says 3/23/25. I'm presuming it was intended to be 3/13/25, signed by all 12 jurors. This forfeiture specification to count 2. We, the jury, find that the state of Ohio did prove by clear and convincing evidence that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to forfeiture to the state of Ohio, dated 3/23/25, signed by all 12 jurors. Count 3, possession of cocaine. We, the jury, being duly impaneled and sworn, find the defendant O'Shea Lopat Jordan guilty of possession of cocaine as charged in the indictment, dated 3/23/25, signed by all 12 jurors. Forfeiture specification to count 3. We, the jury, find that the state of Ohio did prove by clear and convincing evidence that the pipe, cocaine, firearm, magazine, ammunition, and marijuana is subject to the forfeiture of the state of Ohio, dated 3/23/25, signed by all 12 jurors.
I think he's going to
Count
object.
4, soliciting. We, the jury, being duly impaneled and sworn, find the defendant O'Shea Lopat Jordan guilty of soliciting as charged in the indictment, dated 3/23/05, signed by all 12 jurors. As to the foreman, juror number 7, 2 of the dates are 3/13, the remaining are 3/23, I presume that they were signed today in the jury room, is that correct? Yes. All right. Does either side wish to have the jury polled?
No, Your Honor, thank you.
Mr. Jordan, do you wish to have the jury polled?
No, Your Honor.
All right. Thank you very much, ladies and gentlemen. If you go back to the jury room, I'll be back to speak to you in a little bit. That's all right.
Guilty on all charges for Mr. O'Shea Jordan. Oh, the jury's released, so we got to see them now. Yay. Thank you. They usually release identities. Northwest. He's not a sob sit. Did I say he was a sob sit? He started out as a sob sit, challenged the authority of the court, and then he dropped that and just went pro se.
Have a seat.
Well, how'd that go for you, Mr. Jordan? How do you like
your...
your...
order that a pre-sentence report be conducted as well as a drug and alcohol evaluation. I'm going to set the sentencing for April 16th at 3 p.m. Mr. Jordan, you're going to need to go over, and I'm going to continue your current bond. You're going to need to go over to the probation department and begin the process of the preparation, yes, of the pre-sentence report and drug and alcohol evaluation. Do you know where that's located?
Ask for a
It's in the Lake County.
No, ask for a mental health evaluation.
Third floor.
What she said.
Take the elevator up to the third floor and check in up there. They'll be expecting you.
Okay.
All right. Anything further from the state?
Nothing further from the
Ask
state.
for a mental health
Mr.
evaluation.
Jordan, anything further from you before we adjourn?
Could I also ask for a mitigation penalty? How do you pronounce that?
Mitigation penalty.
Mitigation penalty?
Like a psych evaluation, mitigation for mitigation of penalty.
All right. You know what I'll do? I'll order a psychological evaluation, which will encompass the drug and alcohol evaluation also.
All right. Thank you.
All right. Anything further?
Nope.
He gone. Me on that date again for
4/16 at 3 p.m.
All right. Thank you.
All right. We're adjourned.
He gone. There you go. All right. So now we're done with that one. And it ended about how we expected it to end. Oh, man. Let's see. Now let's jump back to where we were watching the video with in court. I think.
Okay, can you stop? Mr. Levesque's not even looking at Kyle.
I think we're a little bit behind this. Okay, super source box. 3 is going to be 2.
Stop it again. That didn't go in your driveway either, did it?
No.
Thank you. Good to go again.
We're back where we were. This is a smart move by the defense. I don't like his style.
Okay, sir, you stop. He's not plowing anymore, right?
No.
And who is going out through the driveway again?
That's Kyle.
Okay, can we back it up just a second? Is this when you looked outside?
No.
You did not look outside at that point?
No, me and my daughter were in the living room at this point. You can see the curtain move when you look outside.
You did not see Kyle go into the driveway?
No.
Okay, can we go?
Right there.
Okay.
Yep, there it goes.
Yep, there he goes.
Yep, you can see Mr. Levesque get out of the truck right there.
Okay, can you stop? Mr. Levesque's not even looking at Kyle, is he?
That's what I was referring to when I said that. He was out of his truck. You could see him by the car door.
You didn't say anything about, uh-oh, he's getting out of the truck. You didn't say anything like that.
No, that's just how I worded it. I'm sorry. I don't know why I worded it that way.
Well, let me ask you. That's the first time you saw Kyle, right? Right out the window.
Yes.
There he goes.
Yep.
Yep. Thank you. Take a seat.
Now, you're done with the video?
I am.
Thank you. You will be shut down.
first time you see Kyle through the window, your first statement is, "There he goes," right?
Yeah, that's what it looks like on camera, but that's not what I was referring to.
Again, that's what it says, and that's what it looks like on camera, right?
Sure, that's what it looks like.
And then the second thing you say shortly after that is, "I hope he doesn't do anything stupid." Right?
Yes, I do say that.
And you refer to the same he, right?
Yes.
And then the last thing you say is, "I hope he doesn't do anything fucking dumb."
Right, I do say that as well.
And as we look through that entire video, and now that you've seen it and it's fresh in your mind, fresh in your mind,
yes,
you will agree with me that Jason plowed no snow in front of your driveway.
He might have stopped his plow at the telephone pole, but every time he piled more snow, it pushed the snowbank in front of my driveway.
And I'm sure the jury will take a very close look at that video.
I'm sure they will too.
Thank you very much.
Wow. Why don't you just spit at her before you sit down?
You know, look, I don't want to belabor this plowing thing too much, okay?
Right.
But I just got to ask you, you saw these kind of 4 swipes towards your pole.
Sure.
Do you know the sequence of Mr. Levesque's plowing of his own driveway?
What
you know, in other words, do you know what was going to happen to the...
It's straight speculation.
Sure. You had mentioned a prior kind of plowing incident that raised some tensions.
Right.
Did that prior plowing event actually come to an end? Did he finish plowing?
He did finish plowing.
Did he complete?
Did it appear that he had
plowing?
finished plowing in the video that you saw?
No, he was not done plowing.
Okay. Candidly, those are all the questions I have.
When was that other thing, so we can be real accurate?
I couldn't tell you the exact date.
Thank you.
All set? Thank you.
Yep.
Please be excused.
Yep.
Ma'am, thank you for your time.
Judge, we have another witness available. I don't know what the court's plan is in terms of brief morning break.
Let's do a brief morning break so we can skip ahead. Stretch your legs, do a little courtroom yoga.
Please rise.
All rise.
Jury departing.
There goes the jury. We're going to fast forward just a tiny bit because we can. So break time is over. I don't know if you had planned to go somewhere, but it's too late now, just for the record. Sit back down. Please take your seats. We are coming back right now. All right. He's a late performer. It's the end of the plowing when all the when the offense occurs with the snow. All the previous plowing was.
Thank you.
All the previous plowing was just building up to the big finish. So we did like 4 run-ups. The 4 went before the big plow finish. But the big plow finish never came. Instead, he shot him, the neighbor, I would say prematurely. So you can gather from these facts whatever you will. But what a case. What a case. I'm sorry, we just came for the 2-for-1 deal. I've got 2 things on my, never mind. So they were neighbors. He had a plow. I think I follow. I'm getting confused, but it's all coming together now. Yes, Mr. Opertorso, the guy who's blurry in the center of your screen right now, a little better focus now. He is the neighbor with the snowplow, and he actually has a plowing company. So like he does this for a job during the wintertime. And he had been plowing the area in front of his house, but as part of his plowing routine, It is his practice to plow the area all the way up to the curb right in front of his house, and his house borders his neighbor's property, that's how they all work. Properties have boundaries. There's a line, and he plowed right up to that line and possibly pushed a little bit more.
Issue, and so we're going to hold the jury for another, hopefully 5 to 10 minutes, and then we'll recommence. Thank you.
Are we having tech issues? The judge goes out through a double door. I never noticed that before. They're like 2 doors on top of each other. Okay, so we're going to fast forward and skip through this as well as they sort through their technical issues. Still happening, still happening, still happening. There we go. And we're almost caught up perfectly. There we go.
Defendant's statement to police investigators. One of them was that after he was initially shot.
I want to catch that last little word. Don't want to miss the very beginning of this little argument. Not a sidebar, but an objection of some kind. What would happen here in the next 5 or 10 seconds. This court has a lot of technical issues, probably because it's not really a court. It's a
through another witness, through Detective Garson,
lunchroom
portions
cafeteria.
of the defendant's statement to police investigators. One of them was that after he was initially shot, that he continued to yell at the defendant in an aggressive manner. Not only did he not go drop to the ground, but he continued to yell. The nature of the injury and the capacity of the victim to actually speak in clear terms is likewise depicted both physically and by audio in this particular image. In other words, he's able to articulate through grunts that he's shot in the face, but these are hardly associated with, I think, the aggressive screams that were depicted or claimed by the defendant in his interview. So for those 3 reasons, notwithstanding the graphic nature of these images, it's the state's position that they're highly relevant and more so than prejudicial.
First of all, thank you very much. We are prejudicial. It's a police do traffic. I will stipulate the bodily injury in fact. This morning, I was shown a series of photographs by the state. I agreed for them to be put in. They all show Kyle, I'll print them up. Every specific wound.
They're trying to bring in his police statements.
The issue of the gravity of the injuries is not at dispute at all. The body cam, and you're going to have to watch it, they're going to remind the voice, but the body cam is unbelievably prejudicial. And the situation can be adequately explained by the witness himself when he takes the stand. In other words, what that body cam will do, it's nothing more, in essence, it's nothing more than a consistent prior statement of what he already was able to testify to. It's not admissible. We're not even going to question it. Right? What he's going to say is that he was spotted. He went to a number of emergency medical procedures, and he eventually handed Kyle off to the EMT. That's it in a nutshell. And he can describe all the injuries he wants, but watching an individual writhing around on the ground, and watching bloody details of ripping off his clothing, it's nothing more.
Oh, they want the body cam.
Kind of prejudicial. It's outrageously prejudicial. Frankly, it's irrelevant at this point in time. We agreed that he had serious bodily injury. We agreed on opening that it was a miracle, that it was extraordinary medical procedures. We went through the whole thing. Okay? I agreed on all the injuries. I agreed that they were caused by both of them. I agree he was in dire straits. I agree he had to go to hospital. And I agree he had to be treated at the scene. I agree he had to be treated at 3 different hospitals. I mean, it's just, frankly, overdone. And when you see it, we'll know what I'm talking.
And I'll again reiterate, the defense starts out with it's prejudicial. It's got to be unfairly so, and there has to then be this additional balancing with probative aspects of this evidence as well. It may be prejudicial in the sense that it advances the state's case, but it is not unduly prejudicial. And to the extent that, again, that the defense characterizes it as unfair by its graphic nature. That is the nature of this case. And they've brought certain issues into, heightened scrutiny by making such claims as he could have killed him if he wanted to, as in suggesting that these sort of were, only partway there. And the other one is, hey, he got what he deserved. In other words, you got to weigh out the words that he made, and the defense wants to focus heavily on that, but now start to discount, filter, and really whitewash the consequences, which are what he deserved. Let's see what he deserved. It's depicted here. And then again, I do want to stress the importance of the fact that he really is diminished in terms of his ability to yell in any kind of threatening manner, which is something that the defendant stated
attempted
during
murder.
His police interview immediately after these events. And that's from the first shot, which I got to say, again, raises a focused probative value here, a heightened probative value. And I think the court can make appropriate limiting instructions that this is not about passion or other factors, but is only considered for the relevance of contested issues. If the defense wants a limiting instruction, the court can take that avenue. But we have, by the way, filtered this jury, addressed this jury from the get-go about their capacity to see and hear and weigh graphic evidence. And this is what we were talking about.
No, this is not what we were talking about. What we were talking about were the specific injuries. And by the way, each and every
they're arguing about showing the body camera footage of the police on the scene providing treatments.
Can be made out by those photographs and the actual observations of the medical personnel at the scene. You don't need to see a human being stripped in the snowbank with blood all over the place, all right, and emergency medical techniques being performed. You don't need that in order to buttress the argument that he was in extremely serious physical condition. And by the way, nobody was there at the time when the immediate gunshot took place, and whether or not he was able to articulate at the time. I agree, he couldn't articulate 3 or 4 minutes later. If that's a bonus contention, take it. It doesn't make any difference to me. Okay? It doesn't make any difference to the case. But what I'm saying is that you don't have a 702 expert coming in here who is a detective in a police department or a fire department that's saying 4 or 5 minutes ago they wouldn't be able to talk, right? I mean, that's beyond the scope here. I mean, we're not notified.
They want to draw. Doesn't mean that they want to draw from themselves, right?
But that's the inference they want to draw. But seeing somebody treated afterwards doesn't maintain that inference. All right? And if you want to backtrack and come to that conclusion, throw a witness on the stand and let's examine the witness.
But the issue in terms of prejudice is whether he would explain that there's passion or
this audio is terrible.
Whether that inflaming the passion or sympathy will override their ability to render a fair verdict.
That's one. But again, what's the need to show this video? Why do we need to show this video? I'm giving a full exhibit agreement to each and every wound on his body. I'm not contesting medical synopsis coming in that will indicate the seriousness of the injuries. And
I'm not sure need is the right analysis. I mean, in terms of the state, to present the case the way it wants is almost not necessarily prejudicial or inflammatory or right.
Well, there's need. Because is it cumulative? All right, here's one question. What is it really saying? It's saying, I am a police officer. I have a body cam. Well, he can testify, all right, to what he saw, what he did. If I cross-examine him and question him, I agree, they can put in any snippets they want from his body cam to buttress his credibility or his recollection. But I assure you, I'm probably not even going to cross-examine this witness.
So, obviously, first step is I need to see the video. Right? I can't make a decision in the vacuum without having seen it.
Right.
Assess the extent to which it would be inflammatory or appropriate prejudice or such thing.
Judge wants to see the video before he makes a decision.
So that I can do the video. So we can let the jury know when these people come up. We're going to have them hang on for a few more minutes. And then we'll make a decision after that as to whether we're going to get the testimony before lunch. Thank you. But I'll decide that in a minute. So what's the easiest way for me to do this video?
Your Honor's preference, I have it hooked up to my computer right now. I can bring it up to the bench and you can do it there. I'm more than comfortable with the chambers.
Yeah, I'm taking the chambers, I mean,
First flash drive, are you able to play it on your phone back there?
no, I better take your advice. They get teaching about it.
Your Honor, do you want counsel as well?
Do you think you'd like that?
I don't need it, but
Counsel, do you want to be there while I watch the video, or do you?
If there's questions, yeah, I mean, I think we should be back there.
Okay.
So they're going to go back in chambers.
Then we will watch the video, and we'll be back. All right.
Okay, so I'm gonna back up a little bit and see if I can play that what just happened with the audio fixed. Let's see if we can do this.
police investigators. One of them was that after he was initially shot, that he continued to yell at the defendant in an aggressive manner. Not only did he not go drop to the ground, but he continued to yell. The nature of the injury and the capacity of the victim to actually speak in clear terms is likewise depicted both physically and by audio in this particular image. In other words, he's able to articulate through grunts that he's shot in the face. But these are hardly associated with, I think, the aggressive screams that were depicted or claimed by the defendant in his interview. So for those three reasons, notwithstanding the graphic nature of these images, it's the state's position that they're highly relevant and more so than prejudicial.
First of all, thank you very much. Yeah. I'll stipulate that the bodily injury is bad. This morning, I was shown a series of photographs by the state.
It's really quiet. He's just away from any microphone.
They all show it. I'll bring them on. Every specific one.
Okay. So let me just tell you, because he's so quiet, I'll just pause that there. I can clean it up a little bit, but it takes a little bit of work to get the audio where we need it, especially when the volumes are different. It's hard to do it on the fly, and it takes a ton of processing power to do this. But what's happening is the state wants to bring in body camera footage of the officers who responded to the scene first, and the first officer who responded immediately began rendering aid. That body camera footage will show up close and personal, like, from his chest view as he's rendering aid to the victim, him cutting the clothes off that needs to so he can see where the wounds are and begin to start treating him. You're going to see, if we see this, and the judge is watching this in chambers right now to make a decision, you're going to see that he got shot in the jaw and it broke his jaw on both sides. You're gonna see that he got has 5 shots, one in each buttocks, shot to the genitals, shot. He got hit a lot. Went in and perforated his bowel. There's a lot of injuries there, and you're gonna see a guy who is like alive but not really conscious, basically being as he's bleeding out in the snowbank. And getting prepped for treatment. The defense is saying this is too prejudicial. They're saying you can't bring that in because it would completely taint the jury, and they'd be like, oh, look how terrible that was. Of course this guy's guilty. But I think it might come in. Now, it's pretty graphic. I'll say it's extremely graphic, but it might be appropriate, especially because when you look at the defense, what they want to raise as an argument is that the reason that the defendant shot additional times was because he still felt threatened because of what the victim was still saying after he was shot the first time. Now, the victim's still talking and still mouthing off, which nobody heard but the defendant. It's very convenient for the story, but is it plausible that he was able to talk with a broken jaw in two places, basically almost shot his jaw off? It was detached and hanging there. He was able to talk and continue to make threats so much that the defendant continued to feel threatened and necessary to, needed 5 more shots while he was on the ground. But then suddenly, as soon as police officers arrived and started treating him, he lost the ability to speak because that's when he realized his jaw was broken. It's not adding up. So if they want to come in and say, but he said this when he was on the ground, I think it's perfectly fair game for the state to say, you know what? Let me show you, jury, the condition of the victim as he lay on the ground. Moments later, and you just, in your own mind, just determine if it's reasonable to think that, yes, just seconds ago, after being shot in the jaw, he continued mouthing off and threatening. So, yeah, I don't know. I just don't see it. Let me see if I can do a little bit more to this audio. Give me just a second. I've got to crank the volume a tiny bit. And remove some of the voice isolation. Let's see if this sounds any better.
The issue of the gravity of the injuries is not at all. We divided in, and we're going to have to watch it. We're going to remind the voice. The bottom end is unbelievably prejudicial. Being publicly exploited by the witness himself. In other words, what that body came to do, it's nothing more, in essence, it's nothing more than a consistent prior statement of what we already were able to testify to. It's not in this.
I'm starting to get a little bit more cleaner sound here.
The number of emergency medical procedures, and eventually on how to be able to. But that's it, that should help me. And he can describe all the injuries he wants, but watching an individual ride around, watching what the details of ripping off his clothing, it's nothing more than just kind of like it's outrageously prejudicial. Frankly, it's irrelevant at this point in time. We agreed that he had serious bodily injury. We agreed on opening that is a miracle, that was extraordinary medical procedures. We would do the whole thing. Okay? I agree to all injuries. I agree that they were caused by bullying. I agree he was in dire straits. I agree with he had to go to hospital. I agree he had to be treated at the scene. I agree he had to be treated at 3 different hospitals. I mean, it's just frankly overdone. And when you see it, you know what I'm talking about.
Okay, so that was that. That's all I worked on. Didn't want to get any more than that. Defense is saying we'll agree to all the pictures. We'll agree to the injury shots. The pictures, the still photographs. We'll agree that he could not speak or did not speak once the medics showed up. But please don't show the video. The judge says, I can't make a decision on this until I look at the video itself. So come back to chambers. He's taken the prosecution's laptop and counsel has gone with him. They're going to watch the video in chambers, and then he's going to say, either this is too prejudicial, this is incredibly graphic and too prejudicial, and there's not enough probative value here, or you know what, this is really insightful, And the jury could use this information to help them form an opinion, and it's more insightful than it is prejudicial. So it's a tough call. It really is a tough call, but I think it's coming in. This is the sort of video that we often do see coming in as evidence. So it's not by default out and then brought in as an exception. Body cam needs to come in. It doesn't need to come in for the purpose of determining how he was injured and how he was shot. But I think it does need to come in, even if it's just an excerpt from it, to show the condition of the victim as soon as he was found, and his ability to respond or articulate any sort of response to those who are trying to render aid. Question: if they don't see it, can the jury see it once in deliberation? No. If the judge does not admit it, it's not coming in. It's out. It's out. 3 is going to be 2. Here we go. Let's wait for them to come back. The judge is deciding right now if the jury will get to see it at all. Super T says, am I demented because I want to see the graphic photos and videos? No. A lot of people find them incredibly insightful. A lot of people can look at that and look at it from a medical or a professional standpoint and be okay. There are others who just thinking about the description of the picture might make them lose their lunch. So it doesn't matter where you are on the spectrum. I don't think it's demented. There's sometimes some graphic pictures that I've been curious about that I've found and viewed just to make sure, I was informed about everything. Sarah says, I really like the design of the seal. Sarah, I'm glad. You may be in the minority on the channel. I think it looks like clip art. It looks like cheap clip art. It's cool. I like the idea, but it's balanced. It's colorful. I think they should have gone the next level up and had like gear teeth on the outside of the seal, so that the whole thing was like a gear. I don't know why. I mean, they've got the nut in the middle, like the bolt, like that's like it's a wheel. Maybe it's a wheel instead of a gear. I don't know, a wheel, like a tire would have, unless it's like an old Model T or something, it would have multiple lug nuts. This one just has that center nut, so it's either a race car wheel, like a Formula One vehicle, or it appears to be a gear with the 4 spokes. It's balanced. Is that Rochester District Court? Stratford Superior is super old. This is the seal of Stratford County. Oh, coming back right now. Judge is making a decision, or possibly already has.
No, we don't need a jury.
No jury yet?
All right, the court, I'm going to understand. The court at this point has had the opportunity to view the video. I would like some additional time to consider the issues, and before I make my final decision, given the timing, it's now 11:42, I think it makes sense to take the lunch break now and tell the jury we're going to break for lunch, and we're going to come back here at
get another break.
1 and quarter of 1, and we'll do it that point, and I'll give you my ruling at that point.
Can we do 1 o'clock?
All right, we can do 1 o'clock, that's fine. We'll give them a little bit longer lunch break. So if you have the jury control, we're going to start back up at 1 o'clock, with my apologies, and we will do that.
Understood. Thank you, Your Honor.
Your Honor, brief clarifying question. We discussed in chambers a cutoff point in the video where there's some extraneous footage that I think both parties agree is particularly necessary in this case. Is there an assumption that video would be then edited down?
Well, let's cross that bridge when we come to it. Just figure out.
I only ask because it'll take a few minutes to make those edits on my end, so I
think that can be, I think you can assume if I'm going to, if I were going to allow it, it would be shorter than what.
Okay. That was essentially my question. Thank you, Your Honor.
All right, thank you very much. We'll see you at 1 o'clock. All right. I don't think I need to see it. Okay. I need to do some legal thinking, but I don't need to see the video. All right, thank you.
So through the static, what happened there is the judge came in and said, I'm going to take a little bit more time to make a decision. I've had the opportunity to view the entirety of the video back in chambers. I'd like a little bit more time to think about it. Obviously, he thinks that it's cutting it close. That probably means it is A, very graphic, and B, potentially very probative as well. So he's gonna weigh that one out and see where it ends up. Which means it's lunchtime. We're gonna be going to lunch. We're gonna be coming back in 1 hour. I've made a portal already. It's already created. So you guys will be able to be portaled over directly from here to the new live stream in the afternoon. I think I have to go to the post office because something's there waiting for me. Wagon wheel, or do you not have horse-drawn carriages in the States? Ninus, I happen to know from your profile picture, you're aware of the current technological revolution and where vehicles in general have developed to. We don't use very many horse-drawn carriages anymore. I know you might be watching some videos and stuff where it appears that way. It's just a show. It's just a show. Most of us drive cars. Most of the cars have at least 4 lug nuts, generally 5 or 6. We don't. I mean, we reenact some stuff with wagon wheels, but less in Amish town. Yeah. Yes, incredibly graphic is what we expect to see. Not sure if that's going to be shown on the screen. If it is, it'll be shown from the side. So, do you guys want me to take photos outside the courthouse? Says Judge Canono. Yes. Send me a photo. A nice. I'm thinking. Well, not like Hallmark type photo, but just a nice, clean photo of the front of the courthouse. We can add it to the thumbnail. See if we can make the plowing the courthouse as well. All right. With that, it is time for lunch. We get 1 hour. I'm just going to go to the post office. I'm not really going to eat because Mrs. already brought me a snack. Had some walnuts, little cup of walnuts, and a sliced apple. Made me think I was a kid in school again. Getting a snack halfway through the day. When we come back, part 2 of day 2 of this trial, the Snowplow shooting trial. Bad neighbors. At least one bad neighbor. But we'll see where this one goes. We'll see if the judge makes a ruling. We'll see if we get to see what actually happened to the victim, Mr. Violet. Not violent, Mr. Violet. But we'll be back. We'll be back at lunch. We are portaling, so you don't have to go anywhere. Just sit tight, keep your arms and feet inside the right at all times. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again in about 1 hour from right now. We'll be back at 12:45. Portal incoming. We'll see you guys on the flip side. Have a good one. Bye-bye. May be bumpy, Joe. Here we go. See you in a minute.